how to handle data processing requests from customers. That's our topic for today's MSP Zone.
You're entering the MSP Zone, a podcast for the managed services community, covering news, analysis, and interviews from around the globe. Elevate your MSP game by staying in the MSP Zone. And now, your host, Charles Weaver.
Oh man, this is going to be an exciting episode. Exciting! But we're talking about data processing. How can it be exciting at all? No, trust me, it's going to be exciting. There's going to be a lot for us to cover today. And it's not going to be all legalese and complexity. It's going to be broken down, made simple so everyone can understand. And it's going to be something that every MSP ought to be considering if you're not already considering it. And I wager there's a lot of you guys out there that are not thinking about this stuff, and you're just going through the motions. You're signing documents. You don't even know what you're signing. After today, you're going to have a whole new perspective on that and hopefully put your practice on the right path towards compliance and security and all that fun stuff. So let's dive right into it. Joining me again from the great state of Texas is our friend Rob Scott. Welcome back to MSP Zone.
Thank you, Charlie.
All right. So, Rob, for the average MSP that might be maybe starting out their practice, this year or last year, there's a lot of them, by the way, a ton of new startup MSPs. Or maybe you're a legacy MSP. You've been doing this for a while, but you know what? You've heard about data processing. You think you have an understanding of what it means, but maybe you don't really. Why don't we start at the beginning? What is your definition, Rob, of data processing?
Look, I think about, in the broadest sense, data processing is everything that MSPs are doing with customers. It includes consulting, it includes hosting, it includes accessing. The definition of data processing is very intentionally broad, and it's meaningful because there are a number of international, federal, and state regulations that come into play when an MSP is engaged in data processing, and that processing involves data that's regulated by one or more laws.
So it's can we generically call it as the MSP's handling of that data?
You can, but it's almost misleading because you don't have to handle it to be processing. You don't actually have to access it
really
to be processing.
You mean potential access, potential handling, the ability to have that. Is that closer?
I think one way to describe it, under, for example, federal law in the U.S., the concept is permitted access. You don't have to do it, but you could.
So I get a lot of MSPs who say, I'm not really certified because I don't host anything. I'm not a hosting provider. And they think that because they don't host something that they are excluded from having to demonstrate compliance. It almost sounds like that, where it's not that you don't have to host anything, it's that you have potential access. We call it logical access. And it's that logical access to data that implicates the MSP in this data processing examination.
Correct.
Okay. All right.
That and a law that would be applicable.
Understood. And we're going to get into very specific examples of laws and rules that implicate this. So, in the context of, right, because this is an ongoing series that we've been doing about MSP contract negotiations, and in your experience, how or when does the concept of data processing typically come up in the course of a customer MSP relationship?
So the data processing terms of a managed services contract can be a significant portion of the negotiations, particularly as you get into mid-market, certainly enterprise. In the SMB space, you're likely to see it with heavily regulated clientele, such as small hospital groups or doctors' offices or dental clinics. These are all, subject to HIPAA in the United States. Or you have financial institutions, could be small credit unions, could be, car dealerships that are giving a lot of car loans out, or payday loan services. All of those would be regulated under GLBA. So it really is going to depend on what vertical is, what laws apply, and then the best way to think about it is the MSP becomes subject to that regulation by virtue of becoming a service provider for a customer that's subject to the regulation.
Okay. So let's pick something that's fairly ubiquitous, common amongst the practicing MSPs in the United States, and that's healthcare, right? So certainly, if you're a mid-market enterprise player in managed services, as Rob just said, you're likely going to have this very explicitly raised as an issue during the contract. And Rob, we are talking about the contract phase of discussions between MSP and customer, correct?
That's right.
Okay.
These discussions regarding data processing terms become part and parcel of the either renewal or new engagement customer contract stack.
Okay. Now, taking the example of healthcare, because, and I'm taking that because we've got a fairly significant federal law called HIPAA that has been on the books for a long time, and it impacts enterprise, mid-market, but most importantly, a lot of these small, medium business market, SMBs, because they are doing business with small practitioners' offices, a dentist office, a medical clinic. The SMB customer is very likely to be a medical practitioner or in some way covered by HIPAA. So in that scenario, you probably have seen some examples where it's not just at the contract stage, but it's maybe even after, like many years after, correct? And how would that manifest itself?
The MSP gets a letter from the customer that says, in light of our obligations under HIPAA, all of our vendors have to sign this agreement. And it's styled as a business associates agreement. It has frequently the elements that are required under the statute. But my concern has been that a lot of times it includes a lot of other things that are not required by the regulations, but are really just a renegotiation of terms that I think should be handled in the master agreement.
Okay, so if you are an MSP out there listening to us and you have an existing relationship with a managed services customer who has already signed an agreement, Rob, what you're saying is the presence of hey, would you mind signing this BA agreement? It's just to cover us for HIPAA. In your opinion, that is potentially, first of all, it's an important thing, right? Don't ignore it. But secondly, don't necessarily sign it because you might be renegotiating or reopening and potentially contradicting what you've already agreed to with that party in your master service agreement. Did I get that right?
Correct. And to go one step further, we recommend that all MSPs that have any healthcare vertical have a standard HIPAA business associates agreement that complies with the regulations and does nothing else. And you give that to your customer that's in healthcare, and that you tell that customer, this is our BAA. We don't deviate from this. This is the one we use.
I'm not signing yours.
Yeah,
you sign mine.
Ours.
Yeah. Okay. So aside from, it's MSPs like anybody else, right? They follow or like to follow the customer is always right mantra, which I get as a customer service concept, but this is this is serious stuff. This is not just a make everyone happy no matter what the cost. There are some real repercussions. We just talked about potentially conflicting documents that could cause problems if there's a breach down the road or a contractual debate or question. This is coming up significantly and frequently, that you think that the MSPs ought to have their own BA agreement, and they ought to have some sort of provision in their agreement templates that talk about data processing in general. Is that correct?
Well, 100%, and in a number of different places. First and foremost, in our master agreement, we specifically list a variety of privacy and security regulations and expressly disclaim compliance with, or have the customer specifically say that they're not going to be dealing with any of the data that's subject to the various regulations that are being listed. And if they do, and something goes wrong, they have to defend the MSP and hold the MSP harmless from anything that happens.
So we've talked about healthcare. We've talked about, that certainly covers a lot. Banking, financial services would be another tremendously large market segment of SMB, mid-market, and enterprise MSPs. Just in those two areas, what's your general guidance or observation of the state of data processing negotiations between MSPs and their customers? Like, I feel like it's largely after the fact. It's an afterthought, and they do that by signing an agreement after the agreement has been signed, and they're reopening things, as you said, and potentially subjecting the MSP to even greater risk.
Well, I just feel like the MSP needs to be more assertive than the fact pattern that you described. Every customer should be presented with a data processing agreement that should be available to them based on the nature and extent of the engagement that you're in. If you're engaging with a healthcare company, when you submit to them the proposed managed services agreement, it has as an exhibit a data processing agreement that is focused on HIPAA. Similarly, in the United States, financial services are regulated under GLBA, which has both a privacy and safeguards rules that the customer and the MSP will have to comply with. And it requires, a written agreement. And so if you're in healthcare, if you're in financial services, you need data processing terms for each segment. And, our template data processing terms are modular, so that if whatever vertical you're in, whatever regulation you're subject to, we include those in the data processing agreement, and everything else is expressly disclaimed in the master.
So I'm gonna state a hypothetical here, a hypothetical fact pattern that I think happens more than we realize, but it's if I'm the customer and you're my MSP, and I bring a BA agreement or a data processing amendment document that I want you, my MSP, to sign, it seems to me that in many cases it is a shift of liability away from the customer to the MSP to say, you are going to absolve me of all this regulatory burden that I have because you're my MSP, right? And you're going to make all that go away. Is that a fair statement, or am I being unfair to that fact pattern?
No, my experience has been that when the customers are supplying the BAAs to the vendors, they go well beyond just what's required, and they stray into this rebalancing and reshifting of responsibility. It's both in terms of the regulatory piece, but they frequently will also tie a breach of the BAA and somehow try to carve it out of the limitations of liability that were in the master or relevant service level agreement. So it can happen. There's a number of different ways that a cleverly worded BAA could really shift considerably more risk to the MSP than what was contemplated by the master. So for me, as a general rule, risk balancing issues belong in the master, and they're not part of the regulatory regime because there are no regulations that require the service provider to assume legal liability for an incident.
Right. So for those of you out there taking notes, and we hope you are, what Rob just said is critical, right? Which is, first of all, Rob, this should not be something that a director of IT ought to be signing, right? I mean, this is something that a business owner, an executive, a C-suite person in the company ought to be reviewing and responsible for signing. I mean, is that even debatable?
Same parties that could sign a customer at that revenue band to a new contract need to be the people who have to sign the so-called required for regulatory compliance agreements.
Okay. But your claim that that many of these documents that you've observed actually attempt to change the limitation of liability, meaning that they're going to say if there's a regulatory trigger, like you fail to live up to your regulatory obligation in this new BA agreement or this new data processing agreement, it's going to be outside of the you will not be able to limit your liability. You're on the hook full bore.
Yeah, so they'll use the BAA, and then they'll have a carve out in the master terms that says basically a violation of the BAA is not subject to the cap, would have the exact outcome that you described.
So and again, I'm basing this off of my observations of how many times I've seen this, and it's been going on for like 10 years or more, and I'm sure you've seen it. But there seems to be this belief that amongst the MSPs, again, just sign it, just get away with it, and the problems are done. The customer's happy. We get to move on. The relationship is good. Everybody's smiling. But that's not at all what's happening. I mean, I think you had brought up earlier that's not the end of that issue. That is now the start of a very new and very potentially dangerous relationship or risk to the MSP. Could you elaborate on what that means?
Yeah. So the point there is, you signing up to the data processing terms is the way the government hooks you in to being subject to that regulation. So once you sign the HIPAA BAA, you're subject to HIPAA. You have to be able to demonstrate that you're being compliant with HIPAA. There are a number of requirements that you have to follow. HIPAA, in terms of its security rules, are among, as you said, been around a long time, fairly well developed, fairly well detailed, what you have to do. And as an MSP, you're going to be able to demonstrate that. So just by signing an agreement doesn't, now you're on your way to, you've got a compliance project. You're now got a compliance project as though you were the healthcare provider. You have to have the same compliance programs for HIPAA that the clinic has to have.
Is it your opinion then, Rob, that after, and there's probably thousands of MSPs out there practicing in the U.S. alone who have signed, and probably right now as they're listening to this podcast, they're saying, "Oh my gosh, let's go find how many BA agreements have we signed," and if they're really exposed to HIPAA or whatever regulation that impacts them, then they now have to make good, is what you're saying. They now have to be able to live up to that. It's not the end, it's the beginning of that. And they have a completely new set of, I don't want to say regulatory, but they have to be in compliance, and presumably they have to demonstrate that they're in compliance, no?
100%. That's exactly what I'm saying. And so it's that, and the fact that BAA may have modified the risk balancing or other provisions of your base master agreement.
In your opinion, go ahead.
Go ahead.
Now continue.
I was just going to say, in managed services, we always have to be confronting our customers in a candid conversation about where they are with the agreement, where is the technology, where are you going with your practice, what does your stack look like, how does your go forward stack compare to what's deployed at the customer, and this is part of it. This regulatory and data processing terms thing is part of it. Now, I will say this. I don't think it's necessary for an MSP to get into an argument about whether or not its activity with the customer is subject to the regulation or not. Because the way I solve that is I write my data processing terms in a conditional way. For example, to the extent that the services under our agreement constitute data processing under GDPR, the following terms will apply. You don't need to get into an esoteric conversation with each customer as to whether or not what you're doing is processing. You just enter into a conditional agreement that says, if I do that, then these terms will apply.
So I like that. And let's assume that up to this point, the MSPs may not have had language in their agreements that actually articulated this. Is that part of the reason why these BA agreements or data processing agreements are being, I'm going to call them an agreement. They're amendments, right? If we're following your kind of belief, and I think it's a correct one, that these documents are they are stepping over the line and getting into contract renegotiation. Is it because the MSP's original agreement was absent, or is it just that the customer is saying, oh, I don't care if it's already mentioned in there, I just need you to sign this again? Like, is there a compliance lack of education on the part of the customer?
Yeah, I think it's a combination of a number of factors. Yeah, but I think the point is that the MSP needs to come forward. There would be no reason that there wouldn't be a BAA in the file that triggered them to send you one. If you provide managed services for healthcare, your standard customer contract stack contains a BAA for HIPAA. If they say they need you to change it, you say no.
It's already done. It's already signed. You signed it.
On the website. Here's the link. Pull it down, sign it.
Yeah.
We've already signed it. This is the one we go with. If there's something in the regulations that you think this doesn't cover, let us know. Everything else is covered in the master agreement.
So again, folks, if you're paying attention, we are not saying that you shouldn't ever sign a BA agreement. What we're saying is do it at the beginning of the managed services relationship, have it expressed there, and don't sign duplicative or conflicting versions of that down the road. I mean, that seems like the fairly simple guidance out of all of this.
The other thing to think about, Charlie, is certain regulations require the types of managed services that typical MSPs offer to include a data processing agreement. For example, in California and similar to GDPR, these regulations require a writing that describes the nature of the relationship and the processing that's going to take place. And they also are focused on transparency and full disclosure of any third parties that will be given access to or involved in use or sharing of their data.
I feel like I have to ask this question, but are we at the point, in your opinion, that globally speaking, MSPs ought to have a data processing agreement embedded in their document, no matter where they are, no matter what types of customers, just because it's a good thing to have and it's more than likely to be activated at some point in today, like end of 2021, we're at that point where most MSPs are processing data. Is that where we're at?
100%. At the very least, you need in your master, all of the disclaimers from all of the regulations to make it clear that, to the extent that the customer asks you to deal with regulated data, in violation of the agreement, that you're covered. But so I think every MSP's agreement needs to have significant sections on regulatory compliance, including these provisions. Whether it's in a separate data processing agreement, I would say the vast majority of mature MSPs will need that. The only exception is the startup MSP that doesn't operate in a state that has a law similar to CCPA, and is just getting going with, clearly smallish and non-regulated customers. That's an entity that could wait, because it's going to be in the least strong position to actually comply. And so my suggestion would be, get focused on verticals and regulated industries. But you don't have to do that. You don't need to create the documents and the compliance initiatives if you don't really already have those customers.
A fair point. But again, back to what we said earlier, even the startup MSP is likely in year 1 or 2 to come across a small dental office, a small medical practice, a small insurance agency, someone covered by healthcare or financial services, or a California customer through CCPA. I mean, it just seems like the odds are in favor of even the startup MSP being exposed to some sort of data processing threat.
The threat existed as soon as you take on a customer. And that's why even the startup MSP needs very clear regulatory language in the master agreement. Okay. Whether they're going to have a data processing agreement or not, these topics have to be addressed in the master agreement in a way that will allow the MSP to have the upper hand in the event that something unexpected happened regarding the client. Unbeknownst to the MSP, the client was dealing with regulated data and something went wrong.
So the takeaways for MSPs listening right now are as follows. Make sure your master service, your general managed services agreements anticipate and express data processing on behalf of your customers, number 1. Number 2, make sure that you are not, let me rephrase, make sure you have a process for dealing with requests from customers or their compliance people to sign agreements, documents that might be in conflict with your existing master service or other service agreements with the customer, number 2. And number 3, make sure that once you are delivering these services that you understand whether or not your MSP practice is in compliance with those relevant areas where you are processing data. Did I get the 3 major areas? Did I miss anything?
You did not. That's all great stuff. The other thing that I want to leave the audience with is this is a worthwhile investment, because if you could build a vertical or verticals in regulated industries like healthcare and financial services, you're going to be building the most desirable, the most profitable, and the most valuable type of managed service practice you could build. Because MSPs that are vertically focused in regulated industries tend to be valued higher than MSPs that are not vertically focused and are in non-regulated industries. So while this sounds like a lot to deal with and a big pain in the butt, it's really something that you probably need to be doing anyway for operational excellence and other reasons. And you look at your ability to demonstrate your compliance and your aptitude with the relevant regulations as being a way to develop that vertical, because now you're in the know. Now you're the expert on the regulations that affect IT with your customers. They're not telling you about HIPAA. You're telling them about HIPAA. You're helping them implement solutions for HIPAA because you not only know about it, but you have, you focus in this area and you can help those that are subject to the regulations comply. And so I think that there's a huge opportunity in dealing with these regulations. And for the largest MSPs, my recommendation is you got a data processing agreement that covers healthcare, financial services, covers all 50 states in the United States, covers internationally GDPR and its various flavors. And, truly, if you think about the largest players, they are able to be global in their operations because they are able to allow customers to check the box when it comes to compliance issues. And as you're a growing MSP, you've got to make the choice. Do I want to say no to this vertical altogether and not deal with it? Or is this something that I want to use as a competitive advantage as we move down the road? And that's how I see each of these verticals that are regulated.
Rob, but I agree with you immensely that it's solvable, right? This is not an issue that should paralyze every MSP with fear. No. It's solvable. You can fix this issue and be a safe practicing MSP and convey that assurance and compliance value to your customers. You just got to do it in the right way, I think is what you're saying. Don't make a mistake of it and add to your risk by doing it out of order or signing documents that are in conflict with one another. Do it the right way, your way, and it's going to make everybody safer, the MSP and customer alike.
100%. And, from the MSP's perspective, all this stuff can be presented online through web-based terms. It's not going to add to the paperwork. It's not going to make it more difficult to complete the sales process. Our approach is, to plug into the sales process that's already existing. If the customer is signing a quote or a proposal at this point, there would be nothing else for them to sign. We would incorporate the data processing terms into what they're signing via a link, and they can go out to the web and print it and sign it if they need to. So really, the truth of the matter is that regulation of IT has increased substantially over the last 10 years. And now that we're able to use with confidence web-based terms, MSPs can really make sure that their data processing terms and their third-party disclosure documents are all properly presented to the customer at the time of the transaction, but don't necessarily have to be printed out and create a big paperwork mess for either side.
I love it. So the takeaway is, folks, don't ignore data processing. Don't add to your risk. You should be lowering, not raising your risk. And if you do it the right way, you do it the Rob way, you'll actually make your MSP practice a bit more valuable. That's all for today. Hope you enjoyed it. Until next time.
Thanks for listening. If you enjoyed today's episode, please give us a like. Make sure you are subscribed to the podcast so you will get notified when future episodes are released. We will see you next time in the MSP Zone.